Hi everyone, my name is Josh Worth. I am the managing attorney of Community Title Network's Arlington location, and I am joined today by Robin Mathis. Robin,
I'm Robin Mathis. I am the managing attorney of Community Title Network's Fairfax office.
And I'm Charles Fincher, managing attorney of Community Titles Leesburg, Loudoun County office.
So we're here today to help you navigate the changes to the NVAR forms that went into effect at the beginning of July in light of the recent changes from the lawsuits that will go into effect on August 17th. So Charles, what are the lawsuits that are going to be impacting our industry going forward?
Well, it's the NAR laws, the Stitzer versus NAR lawsuit, and I know, actually, I thought you were the DOJ lawsuit. So, quite frankly, I'm not as, you've looked at that more than I have. So.
The lawsuit involved people who were paying agents that weren't actually representing them, or they felt like that they were adding no value, and yet they were the ones footing the bill.
Sure. Yeah, so the changes are really in light of these two lawsuits. One of them is reached settlement, and the other one is ongoing. The first being the Stitzer case, which generally alleged that the NAR conspired through their practices and rules to pay buyer brokers, to force sellers to pay buyer brokers and to inflate those commissions in violation of federal antitrust laws. And the DOJ lawsuits, which are following behind them, are alleging similar things, which is that the NAR's rules, practices, and policies are also resulting in lessening competition in violation of the antitrust laws. Practically speaking, there's going to be a couple of changes on a high level. The major one is that you're going to see commissions being completely decoupled now. So as we go through these forms, there's new terminology that's very important to follow, because sellers will now be entirely responsible for paying their listing broker, and they may be responsible, depending on the contract and their brokerage agreements, on paying buyer brokers as well.
I think it's good to have just maybe an overview too of where we are in the context of the rest of the country with respect to this and with respect to these lawsuits, because again, the good thing is that within the AR and in DC and Maryland, our associations have pretty much been in compliance with a lot of the issues that had been occurring, had come up within the lawsuit. We have buyer brokerage agreements. People have signed off on those. They've been negotiated. Unfortunately, that's not the way that the rest of the United States has been operating, and that's opened up these lawsuits. And now, of course, we have kind of a sea change that's occurring. But again, I think that it's not, I think in the long term, it's not going to really fundamentally change the way that we in this area are doing business. I know one of the big concerns is how maybe it's going to change the compensation models that we've been operating under. I tend to think that's not the case, because we've got a pretty vibrant market around here. We've had discount brokerages, we've had flat fee brokerages, we've had all kinds of pay for service options out here. We've even had a brokerage a few years ago that wanted to increase from the 6% standard to the 7% standard. All of those things really have not caught on. They have, and again, because the free market has worked. The sellers and buyers have understood that the basically 5 to 6% compensation model is one that has worked well for sellers and has worked well for buyers and worked well within the industry. And I don't see that really fundamentally changing once everything kind of ends up kind of falling out with respect to this.
And I think that's a great point. I just think that going forward, there's going to be practice changes, specifically with how folks are using the MLS systems on how these deals will kind of transact in the normal course of business. The main one obviously being that there is no longer a blanket uniform offer of compensation. It is an additional step that you will need to take now as a buyer's broker or the buyer's agent to ensure that your clients are not paying for your services unless they now may be. So just an additional way that you're going to have to kind of guide and provide guidance to your clients as you enter into these markets.
Yeah, and the good news is that we're an industry that's always in flux and always in change. We've dealt with a lot of different sea changes in the contracts over the years. We've dealt with some sea changes in some of the brokerage models and things that we've had, and yeah, I think that the free market and the competition that we have in here generally has served us pretty well. Is going to end up kind of carrying us through the market. And I think you just have to embrace the change. I mean, it's not. I don't think it's one of those things that you can run away from. No, it's.
There's no running away from it.
Yeah.
And that's what I always point out to agents is we've all lived through so many changes. I mean, the HOA disclosure documents, TRID, people thought we'd never have another closing again because of this 3-day advance notice of numbers to the buyers. So just, conversations are going to be key. And I think with every change, we say that. You must have conversations with your client. You must have conversations with your client. You must have disclosures. You must have discussions. And they're ongoing discussions throughout the entire process. But this isn't the first time that we've all said these same words to the agents and the lenders and the buyers and sellers. Let's just all talk about it, and it will work itself out. It always has. I think we're all here to say it's always worked itself out. If not, we wouldn't be here. So,
And along with communicating how the practice of real estate is changing, I think that agents also need to be very comfortable with expressing their value into these transactions and rehearsing that and making sure that your clients, both on the buyer and the seller side, understand the services that you provide and why you're intrinsic into this transaction.
I think I'm glad that you mentioned the TRID thing too, because I think that probably the thing that's creating most concern right now has been the addition of having the compensation put into the sales contract, which we'll get to a little bit later. But we have that in the sales contract, plus you have the compensation agreements. And again, the compensation for the on the listing side and on the selling side is not going to, again, there's some tweaks to it, but it's not really a fundamental change in the practices that we've had here. And just like with TRID, I mean, there's a lot of hand-wringing that was going over that and how are things going to work. And we've had within our industry just a couple of years ago with the Bureau of Insurance letter and dealing with settlement agents and split settlements and how that was going to work. And quite frankly, again, there was a lot of hand-wringing, a lot of people that were over-analyzing and creating issues. But when people just kind of work together and applied a little common sense, you work your way through it. And the same thing here. You have you're going to have the sales contract and you're going to have your brokerage agreements, and they are going to relate to one another, albeit somewhat differently. But when you really get down into the changes in those themselves, there's not a lot of fundamental change. It's just a change in the structure. Yeah. So I think that, hopefully you can just, if everybody just kind of takes a deep breath and realizes that we're all in this together, we want to make this work. And ultimately, again, on the seller side, every seller out there just wants to make the most out of their property that they can. Cost is one factor of that, but it's not the determinative factor of that. And that's, again, I think that's always been the case. That's why the 5-6% commission model has worked and worked very well over these years. I don't think that listing agents really want to be put in a position of having dual agency and having to deal with all of the pitfalls that deal with that on a global scale. I mean, obviously there's a place for that, but there's a reason why that hasn't been the standard. So I think that those are things that as we go and we look into the specifics of this, I think it's good to just keep that stuff in mind.
That's great. Well, with that all being said, why don't we get into some of these changes?
all right.
So I guess when we get into the actual changes in the NVAR forms themselves, I think that the biggest change has really been under the listing agreements. And so I think that's the one that has the most concerns with that. albeit again with the sales contract. I think that how those relate together are probably the biggest things. The good thing is, if you look at the actual change in the listing agreement, you're only talking about 3 paragraphs. So it's not a wholesale change of the listing agreement. And really, as far as what's new in there, you only have a couple of provisions that are actually new, which really just deal with the decoupling of the cooperating brokerage payments, and so it makes clear that the seller and the listing broker are going to have one agreement, and the buyer and the selling broker are going to have another agreement, and that there's going to be some options for how you kind of show that. So I think that when we get, and luckily all of the listing agreements have the same provisions that are being changed in them. So again, you can just concentrate on paragraphs 6, 7, and 8 of the listing agreement. And so getting into it, under paragraph 6, that's the listing broker compensation. And so the very first thing that they do is they add a provision, they don't really add, they move it up and highlight the disclosure. So again, it says that the listing broker compensation and buyer's broker compensation are fully negotiable and are not fixed, controlled, recommended, or suggested by law or any multiple listing service or association of realtors. So again, that's highlighted at the very beginning to make sure that everybody understands that these commissions are freely negotiated amongst the parties. Then there's it's really subparagraph B that's been added to this. So that's a completely new one for additional listing broker compensation for the unrepresented buyer. So again, provides that if the an unrepresented buyer comes in and enters into a contract with on the property, then the listing broker could potentially negotiate that they have additional compensation associated with that. And again, that could be a percentage, it could be a flat fee. So again, there's some flexibility in there.
And I wouldn't, don't want to interrupt, but I wouldn't shy away if I'm a listing agent from that new provision either, because as we've seen, sometimes having unrepresented buyers in a transaction exponentially increases the amount of work that you may be asked to perform as an agent of the seller. So if that's something that is contemplated as a potential for your listing, I wouldn't necessarily be too shy to have that discussion with your seller ahead of time.
Oh, absolutely. Yeah, I think that hopefully the seller would provide that. I hope that as a matter of course. Although again, I would be kind of careful about that because again, at what point are you now? Do you have to enter into a dual agency agreement with that?
Right.
And is the client really served if they are truly unrepresented? And then the listing brokerage is getting compensation for doing that, but they're not really doing any additional work other than the fact that you have somebody. So again, I think that if that's actually used, I think that there are a lot of issues that can come up and be associated with that. But I think that at least as far as getting the seller to understand that there is going to be, and also to agree in the open that if there's a buyer that comes in, they're willing to pay the buyer. I think that's the real, it's just making sure that the seller is conditioned for that eventuality. So, and then there's subparagraph B, which allows for a variable rate compensation. Now, if we go back up to paragraph A, again, it says that, again, seller will pay broker compensation of, again, you can either do a percentage of the gross sales price or a flat fee of some amount, or gross price plus some other amount. So again, I think that that's not really a change. It's just now that's been kind of moved up in the under that paragraph. And then it makes also clear here that the commission is earned once you have a fully ratified contract, and there are no contingencies under that contract. So I think any other issues or questions with respect to paragraph 6 in there? Okay, wonderful. Then getting to paragraph 7, again, this is the one that I think is probably going to be the biggest issue for the parties, or at least the biggest change. So this is, now you have a new paragraph for seller paid buyer's broker compensation. So again, you no longer have a cooperating brokerage. Those have been decoupled. And so now the seller is going to make an election in the listing agreement as to whether they're going to pay the buyer's broker compensation. And so in this paragraph 7, they can elect that they're either going to pay by a percentage of the gross sales price, or by a flat fee, or by a percentage plus some other flat fee. So, and I think that it's important that there's another provision under here that says, again, the buyer's broker compensation is payable upon settlement. But this next sentence says, seller understands that buyer's broker compensation is negotiable and will ultimately be determined by a ratified sales contract between the seller and the buyer. And again, we'll get into that a little bit more. We're talking about the contract. But again, you have the listing agreement. So in this case, you have the listing agreement between the seller and the seller's brokerage that sets the compensation that the seller is going to pay to that brokerage. Or is willing to pay, right. And then you have the sales contract. And the sales contract is between the seller and the buyer and sets what the seller is going to be paying to the buyer in connection with the contract.
After negotiations have taken place and the parties have come to an agreement. So there's a good chance that you're going to see a lot of situations where the ratified sales contract has a different compensation being paid from the seller to the buyer's broker than is stipulated in these listing agreements.
Correct. And that's where I think we have some of the issues that are coming up and how they will relate to one another. For me, I think that it's, I look at this the way that these things come up in court. And most of the time, if there's a dispute between the seller or the buyer and the sales contract is there, the court's going to look in the four corners of the contract. Right. And they're going to see, well, what are the terms here? Are they definite or are they ambiguous? And to the extent that they determine that they're ambiguous, then they may look at other information. But to the extent that it's clear, and again, we'll get to this when we talk about the contract, I think that they're going that's going to be determinative of the compensation that the seller is going to be paying in connection with the buyer. That doesn't mean that there can't be a separate dispute between the seller and their broker or the buyer and their broker. But I think that the courts would understand that these contracts do kind of work together. And I don't see a judge ruling that if there's compensation on the sales contract and then you have compensation under the brokerage agreement and they basically cover the same thing, that they're going to have a double payment or anything as a result of that. They're going to read those together. And if there has been a partial payment connection.
Going back, I think, to the practicality of a lot of these changes and sometimes not getting too entwined in the words, but looking at the broader picture and what the parties intended here. I don't think any party is going to intentionally seek out to double pay a broker. And I think that will be made clear in later revisions and comments from the association.
Ordinary meaning to ordinary words.
Right. Lawyers, right?
Yeah, I was going to say, I think one of my professors taught me that.
Well, the one thing that we always preach in this industry is communication, communication, communication. This stuff doesn't come up, and there really shouldn't be a dispute on compensation if there is communication amongst the parties. You have a definite brokerage agreement, and you have a definite sales contract. And as long as everybody is communicating with one another, there shouldn't be a problem. So it's now, again, if there's a difference between what's being paid on the sales contract and what's under the listing agreement, then I think it's incumbent upon the agent or the broker, whether it's on the listing side. I would imagine it's more on the selling side, that they would make us aware of that. And we as the settlement agents, again, we go by the contract. So if the contract says that this is what's going to be paid, that's what we're going to do. Now, if we get additional information, somebody says, wait, there's a separate agreement, and here's, it's more than this, and they provide that evidence to us, then we have to follow that also. Again, but ultimately, we have to follow what the parties have agreed upon. So, I think.
So, Charles, I'm going to put you under the hot seat here and ask you some rapid fire questions about how some of these agreements, specifically the offer to pay a buyer's broker, can be advertised. You ready?
Okay.
Can you advertise that the seller is willing to pay a buyer's broker commission on the MLS?
Not after August 17th. Yeah, so at least right now, again, those dates are all changing, but I think we're getting close enough to August 17th. I don't think that has been pushed back. I think the November settlement date, it seems likely to get pushed back now that there's been some sellers that are objecting to the overall settlement. But as far as that August 17th date, I think that seems to be pretty definite.
What about on a brokerage website?
Oh, yes, you can on a brokerage website.
What about on an individual agent's social media account?
And on an individual agent's social media account.
And finally, to the extent people still do it, what about on printed flyers?
And on printed flyers.
There you go.
God bless them.
Passed, 100%.
Well, good. Whew, I was sweating it. So, and then finally we have paragraph 8. And that's with the seller's subsidy. So again, it's a new paragraph. They've separated it out, and it just provides that the seller can make a payment directly to the buyer in connection with any costs of settlement that the buyer may have incurred. And again, we've had a seller subsidy provision. That's not new at all. Of course, the question is, now MLS will have a provision in there for seller subsidies. They will not have a provision after August 17th for cooperating brokerage payments. So that's going to go away. And so then the question is, well, if you're going to go and telegraph your willingness to pay a buyer's broker, is the seller subsidy field in there the means of doing that? My own personal opinion is that it's kind of wonky to do that. But I can also understand that if you want to go and signal to everybody, and that if you're dealing with the MLS, and the MLS is the main point of contact for the brokerages in determining where that compensation may or may not be coming from on a public basis, then I think that I could see in the short term where people may do that. So I don't know what.
Yeah, I mean, the MLS, from the conversations I've had with folks, was aware of that and did try to make sure there are specific carve-outs and disclaimers stating that the disclosure of seller subsidy when you go to list the property on MLS now cannot be conditioned on it being diverted at the end towards a buyer broker compensation. So they're aware of it and are going to include disclaimers on those fields now when agents go to input their listings going forward.
Okay, well, there goes that. So, and really with that, those are the major changes to the listing agreement. So again, other than the decoupling of the cooperating, so no longer do you have cooperating brokerage commissions. You have it separated out between the agreement on the listing side and then the seller determining whether or not they are willing to offer compensation to the seller, to the buyer's broker. So other than that, it's not a real sea change in what we've been doing. So
fantastic.
All right, then I will get right on the exclusive right to represent buyer agreement. And since we're all here talking about compensation, I'm going to skip right to paragraph 8, which is talking about compensation. The first question, and going back to one of your comments that we've already received, is can I get paid twice? Because I'm getting paid under the compensation of the buyer agreement, and then I'm also going to get paid under the listing agreement and the first page of the contract. And the answer is no. Nobody, that was, number one, it was not the intent. It was never the intent. I find it funny that when all of this first came out with the NAR and the lawsuits, everybody was running around like the sky was falling, saying that the buyer's agents are never going to get paid again. That was the one thing we all heard. Oh my God, I'm a buyer's agent, I'll never get paid again. And then with the documentation, they're like, oh my goodness, this is good news. I'm not only not going to not get paid, but now I get to get paid twice. And it doesn't work that way. It doesn't work the other way. It's still where we were. Basically what it's saying is buyer broker compensation, you fill in the blank. It's either going to be a percentage or a flat amount. It says buyer's responsible for payment of broker compensation at settlement. If broker receives any compensation from seller or seller's representative for services covered by agreement, that amount will be credited towards the buyer's obligation. So it spells it out exactly there, who's paying what. So on page 1 of the contract, and I know I'm stealing somebody's thunder, it says seller payment towards buyer's brokerage compensation. So if you fill out 2.5, this is the other question. If you fill out, I'm a buyer broker and I get 2.5, and it says 2 on the front page of the contract, you've got a 0.5 point at play out there, and it's up to your buyer to pay that. Now, yes.
Let me ask the flip side of this question to you. If you agree with the buyer in this agreement that the commission that the buyer broker will be paid is 2.5%, and the seller is willing to pay 3%, what is the commission being paid to the buyer's broker?
2.5. You are not to benefit from anything outside of your agreement. Whatever the seller has going with the listing agent is separate from what you have agreed to take as the buyer.
And can you fill in, what folks used to do is print in the words as per MLS. Is that still acceptable?
You know what? That's a great question. No, I would think, no, I was going to say, no, because it says specifically in here, broker may not retain any additional compensation from any source that exceeds the broker compensation. So you've defined it, you've said it, you're done.
Absolutely.
The question is can I, as the agent, say, oh, they're such good friends of mine, and I said 2.5, but they only offered 2. Can I waive that half between you and your broker? Because keep in mind, the document is not signed by the agent.
That's a great point.
Document is signed by the broker. So as we do now, an agent comes to us and says, hey, I'm going to pay $500 to repair a light fixture. What do? Have your broker send us a letter saying it's okay, because whose money is it? It's the broker's money.
Absolutely.
So, there we are. You're not getting paid twice. You've set your payment, and anything gets credited from the seller side.
But I think it's important to note too, yes, the brokers and the agents are not signatories and not parties to the sales contract, but they are third-party beneficiaries under those provisions, especially with respect to the compensation. And and this is where I think communication comes in, because if you have a situation where you have on the buyer's broker side, you've got an agreement for 3% compensation, and then the seller offers 2 or 2.5%. So now there's a delta there between what this buyer has agreed to pay the broker and what the seller has agreed to pay the buyer. Oh, I'm sorry.
No, that's exactly what I wanted to talk about, was how do you handle that delta? And again, I think it's conversation, just like you said. And that is, hey, buyer, you've promised me 2.5. My showings to you will have a stack, and I will know as part of my homework what the compensation is going to be that's being offered. Now, if they're offering me 1% and you've promised 2.5, then it's going to be our discussion as to how we're going to handle that. Do you want to see that house? And the second interesting set of conversations that we've all had on this is this buyer agreement shareable to us as the title company? And I know that Josh is going to cover this because it's in the contract, and that is we have to see this, and it is permissible for us to see this. What I envision with the people that, work close to the chest is that the buyer has to come out of pocket, say, a 0.5%, and their lender doesn't know it because they haven't shared this with us or the lender. And we get to the table and they say, oh, by the way, you have to add an extra 5K. And a couple weeks ago, I did a closing where there was $150 that had to pay off on a credit card in order to qualify the buyer for the loan. So if we're haggling over $150, $5,000 is going to be a major kick in the teeth. Sure. Yeah, it is. And then I am going to get on the phone with the lender and say, hey, I have a change to your CD. And after they get off the floor from laughing at me, and I tell them it's $5,000, you want to talk about a non-closing at that point? So this buyer agreement, the listing agreement, all of the broker compensation agreements are all defined and named in the contract, and they have to be shared, and the privacy
in some form. Yeah, I think that you're going to see, if there is concerns about the confidentiality of those agreements, we'll start seeing more broker letters and authorizations from the sellers and buyers that are signed at the same time, either authorizing the release of those brokerage agreements or a short form, essentially.
And I hope we don't get there. I really hope we don't get there. That's one more, these poor brokers, I mean,
I think it's an easy change to navigate, but it's going to take time to kind of get there.
Yeah, I just hope that it doesn't. I just think the brokers are having to, get involved in too many deals with too many numbers and let's just keep it simple. Give me the document that says what I put on the CD. That would be easy, right?
And I think that's the main point is that if you are the selling agent and there is a delta that so that the seller is not fully covering the compensation that you and your buyer have agreed to, it has to be brought up at settlement. If you don't, I think there is certainly an issue of a waiver. So if later on they then wanted to go to court and try to enforce that, because the agent is there as part of the entire process, they've been negotiating, so they know what's in the contract, and they go through settlement, and it's on the settlement statement, and then subsequently, so there's a number of times when the agent or the brokerage could have intervened and made sure that there was a collection of the full amount on there. If you sit on your hands and you don't tell anybody, and it gets past the time of settlement, even though there may be a legally enforceable document for additional compensation on that back end, you have issues of waiver on there and other issues that I think the court. Yeah. Well, and why do you even want it? The fact is, why are you putting yourself in a situation where now you've got to bring a suit against your client? That's time, money, cost. Loss of goodwill.
Well, as a selling agent, I mean, why don't you just add it to the conversation up front? We're going to go look at Smith Circle, 4 bedrooms, 3 baths, price is $550, and the offered compensation is 2%. That's not, I mean, I'm not an agent, but that just doesn't seem like that's a big deal to me. And that way they go, oh, okay, 2%, I promised 2.5%, I know it. I'm going to hopefully disclose it to my lender. And if not, we are, when we have to balance the numbers for the CDs, we disclose it. So I think, again, and we keep saying this, discussion and communication, discussion and communication.
Absolutely. Great.
Going to the sales contract now? Getting the real meat and potatoes? All right, so the sales contract did have some changes to it as well, some in light of these recent lawsuits and settlements, and some other ones that are in light of changes in Virginia law. The first section, which we've been talking about a couple times already, is the change to the first page, where you're going to see a new line item that specifies the amount that the seller will pay the buyer's broker, expressed as either a percent or a dollar amount. We just mentioned that there are certain third-party beneficiary rights of the buyer's agents and listing agents that are also now written into the contract. So it's just an additional paragraph on that sales contract that you'll see now but make sure that it is in compliance with what you have agreed to with the parties, and make sure that's in compliance with your brokerage agreement as well, to the extent that is applicable. The other section that you're going to start seeing some changes on is that paragraphs 3 and 27 were changed to clarify that you're going to be using business days and not calendar days when calculating certain time periods. And for folks like me that work in Virginia, DC, and Maryland, it's always a hard time keeping track of what's calendar days, what's business days, when do I start counting, what time of the day was this ratified, things like that. Quick little cheat sheet for the NVAR contracts. Business days are always going to be used now for your earnest money deposits and for calculating when settlement is. For earnest money deposits, obviously banks are closed on weekends, so that's more of a practical change they implemented to say, okay, if you ratify on a Saturday and you have a 1 day to deliver an earnest money deposit, there doesn't need to be a rush or concern about calling a closed title company to get wire instructions or delivery instructions. That will all take place the next business day on a Monday. Keep in mind, federal holidays always impact that as well. The second is for settlement. This is also now going to always be on days that are not weekends or federal holidays. So just important to keep those in mind. For everything else, for your financing contingencies, your notice is in relation to those contingencies, the time you have until to contact your settlement agent with that ratified contract, HOA condo review periods, which we're going to get into in a moment as well, and inspections are all calendar days. So it's only 2 changes that are business days here, but always important to keep that on top of your mind.
Well, and I think that's a great change too, because again, you've had a lot of times where you get these, in-state 4-day weekends that
Right.
people aren't aware of, and then you've got 3 to 5 days that you're trying to get, whether it's your earnest money deposit or something. And of course, banks may be closed. I know we just had the July 4th holiday, which July 4th was on a Thursday. Then Friday, I know some banks were open, some were closed, some courthouses were open, some were closed. So that does add another little level of uncertainty, unfortunately, into the process.
Right, and if you're an agent also, no one likes getting the calls of saying, I haven't heard from the title company, saying I haven't gotten my earnest money instructions, and it's a Saturday, and now you can say, it's okay, relax, it's going to be on Monday, we're going to get it to you.
Delivered to my house because of that. So yeah, this makes it much smoother and easier on me. The other thing I wanted to point out was paragraph 4. When something doesn't fall on the business day, it's the prior business day. For years and years and years, it was after. And so again, it's like, oh, this is on Saturday, I'll just see you on Monday. And it's like, no, I think you better see me on Friday. Yeah, so.
Always important, even the small details matter in the contract, so always important to make sure you're aware of when settlement will be and when the important deadlines of the contract are, to ensure that both you and your clients are always protected adequately, right? The next major change that I'm going to talk about is, honestly, even in light of all the changes from the settlements relating to these commissions, what I think is a huge departure in the contracts, and that is the changes to the periods in which you have to review resale documentation. So if you recall, a couple of versions of the contract ago, there was a change in Virginia law regarding the delivery of resale documents and how long folks had to review those. When that law was originally enacted, there was some question as to whether the legislature had inadvertently removed the mandatory 3-day protection. For months, I always thought that they were going to close that loophole, but turns out people may have enjoyed it, and now it is codified into Virginia law, and you see it in your contracts now, which is the time periods you have to review condo or homeowners association documents is entirely negotiable now. The 3-day mandatory period is gone. The first question I will ask both of you is, what's your take on this? Do you think it's a good idea to offer folks less time to review these documents?
I always thought 3 days was certainly reasonable. I know what I've had happen over the past month, or a couple of months actually. We've had buyers and sellers agreeing that they would not, that the seller would not provide, and the buyer was okay not receiving the resale disclosure documents. Now the problem with that is that because that's so baked in with the way that the associations operate, if a disclosure packet is not ordered, it's our experience that the associations then will not provide us any of the financial update, any fees or anything. So we're kind of stuck. So when that has happened, we've had to prepare and have the parties sign a separate document saying, look, we don't know whether there's any special assessments. We don't know whether they are in arrears in their association dues. We don't know if there's been a change or even really what the association dues are.
Right.
So you all are essentially on your own. You understand. One, I hope that legislatively they will tell the associations that regardless of whether it's a disclosure packet, they need to provide that information. It's they really shouldn't hold it hostage to that. But that's just the practicality of where we are with these if you don't receive it. And
Absolutely. So a couple of things that I'll mention is, one, this change does not obviate the need for the seller to deliver the resale package, or at least a notice that one does not exist. So that requirement is still in the law, in the contract. They still have to deliver it. What's changed now is your ability to negotiate the time in which the buyers have to review those documents. So in situations where folks say, well, lots of times we're getting questions now, it's folks asking, can we lower it to 0, 1, or 2 days versus the standard 3? You could always lower it. If you do lower it, I would recommend getting the notice of adverse consequences signed by that buyer to protect yourself as the agent. One thing I will also notice is that it's negotiable now. Just because it's not 3 doesn't mean it can't be 5. So if the market turns and buyers start getting more leeway in terms of reviewing some of the more complicated packages that we see from time to time, you can now actually write in 5 days, 6 days, giving them more time to fully parse through all those documents, budgets, meeting minutes, things of that nature.
But if I'm the seller taking the,
You may not want to agree to that.
exactly, why do you have that many more days to void the contract? Because that's the whole, not the whole point, but that was one of the benefits of the HOA docs to the buyer is, hey, I've got that many days. I, being the simple person that I am, I would rather not negotiate something like that. You asked what our opinions were. You know, this is not the opinion of Community Title, but Robin Mathis. And that is, Robin Mathis is a simple person. I just want a number in there. I want to see it. I want to know what the rules are. I do not like the fact that it's one more thing.
If it's left blank, do you know what the default number of days is?
I do not, but I have to assume it's
3 days.
3. Yeah, it goes back to where we were. Yeah.
But I think there's a trap in there though too, because again, the whole point of that statute was to make sure that the seller provided those disclosures to the buyer. The buyer had ample time to review it, and if they wanted to get out, they would get out. So they wanted them to have it out of the contract. Now we've added an element in there of negotiability. And so I think that the danger is some people hear, oh, the disclosure packet is negotiable. It's not, because if the buyer does not receive it, the buyer can get out of the contract, pretty much no questions asked. So up until settlement. So they could be there just waiting in the reception area to come in and decide, I just don't like the look on their faces. I don't want to go. And there's not a damn thing that anybody can do about it. And I don't know why any seller would want to put themselves in that position. But so I'm not really, this is a solution that was searching for a problem. I don't know why they did it. I think that, again, my concern is that when agents hear this and they hear that there's a portion of this that's negotiable, that they think that all of that is, and that somehow, so again, make sure, just emphasize that if they don't get it, buyers can still get out of that contract.
On the flip side of that, one question that I've been receiving recently has been, for agents that know of the importance of delivering it, and while the contract is being worked on, hasn't been ratified yet, they say, oh, here's all the documents, by the way, for once for ratified. Folks are wondering, when do you start counting days from that period? Is it when it's delivery before ratification, or is it ratification? And if you look at the contract itself, that 3-day period or whatever period you now negotiate to starts at ratification and not prior to.
Right.
And the other thing about that is delivery. But I laid it on the kitchen table of the house. Unless it says laying it on the kitchen table at the house is delivery under your contract, it's not.
They did make a change, though, that delivery now can explicitly be made to a buyer's agent or the either agent now, which is a change from the prior versions of the contract as well. And then the final thing that I'm going to talk about is off of the conversation that Robin, I know you and I have been having, which is there any authorizations in the contract itself for the brokerages to provide us as the title company copies of those agreements? These are not new changes to the contracts, but if you look at sections 4 and 22, the settlement agent does have responsibility to collect all commissions. They're authorized to collect the commissions and pay them on behalf of the seller or the buyer to the brokers. So we need to collect documentation in order to adhere to our obligations as settlement agent to the contract. Other than that, as we kind of mentioned, a lot of these changes were not necessarily so substantive. A lot of them are more stylistic and are going to impact maybe more of your day-to-day practice, but within the contracts, we hope you'll find that this is easily digestible and that, as we said a couple of times, everything will be okay. So thank you very much for joining us.
Thank you.